Welcome, welcome, welcome to the Spice of Life Variety Show. We certainly love you and I'm so appreciative of you tuning in to the show. Grab your pen, your paper, and we're going to turn our information over to you at the end of the show. Email address, the phone number, etc., etc., etc. We can contact us and let us know what your comments, what your prayer requests might be. We certainly bid you welcome and greetings from the West Angeles Church of God in Christ, where Bishop Charles E. Blake is our pastor and First Lady May Blake is our pastor's wife. We love you. Thank you for tuning in. Pamela Webb, how art thou?
I'm great. How you doing, Dr. Lewis?
I'm doing wonderful.
Are you enjoying the sunshine today?
Oh, yes.
Isn't it a gorgeous day?
Sunny California.
I know you like it.
Oh, I love it.
I knew it.
You know, I
knew
love
it.
Hold this right here. Let me show you.
Don't stress. We have some good information.
Okay, all right.
This is a part 2.
Okay.
We're going to be talking about estate planning.
Planning.
Yes.
Planning.
Planning.
Okay.
Getting our business in order.
Something we don't like to do.
We don't like to do, but we must do it.
Oh, okay. All right, then.
All
Well,
right.
I tell you what. Let's introduce to you, our audience, our distinguished guest, attorney Sheila Bankhead Grissom. Welcome.
Welcome.
All right. I'm so
Thank
glad
you
to have. We're happy to have you.
Thank you for having me again. Glad to be
For
here.
part 2 of estate
Part 2.
planning.
Yes, yes.
How long have you been an attorney?
Well, I've been an attorney for quite some time, almost 20 years. I can't believe it's been
That's good. Awesome.
that long.
That is amazing.
I graduated when I was 10. So.
That's right. We can calculate that. Okay.
And what's your area of specialty?
Civil litigation, which means I don't handle criminal, I don't handle family law, but I also am interested in work in the area of estate planning.
Okay.
So that is an area that I think is of great importance and need in our community especially.
Why don't we get a definition of the estate planning?
What does it mean?
What is
Correct.
estate planning?
Very good. As we talked a little bit last time, when people hear that term estate planning, they hear that term estate, they think of big mansions and big bank accounts, or they think, well, I don't have to worry about my estate until I'm 1 foot in the grave.
Right.
But estate planning really encompasses a variety of responsibilities. It encompasses various tools, and I'm going to talk a little about the instruments of estate planning, but it also encompasses various tasks. We know that when we talk about a will, we're talking about passing our assets on to our beneficiaries, our heirs, at our death.
Yes.
And we talked a little bit last time about how wills are very common, but when you have a will, you have to go through probate.
Yes.
And probate has problems with it. Last time we talked about the fact that a probate is public, which means that all the information, your will, it means that what you have and who it's going to is all public. It goes through the courts. But I wanted to bring up a couple of other issues or problems with probate as well, and that's why sometimes we want to avoid a will. We talked about the cost and we talked about the expense. Very often a probate can take several months, even 9 months or so to probate. It takes quite some time. But the other thing is when a will is first prepared to be probated, notices have to be publicized to all potential heirs and very often creditors too. So you sort of put a big bullseye in front of your estate and say, come get
Here
me.
we are.
And what that means is that creditors can come and try to deal with trying to get a little piece of that pie, and it may be creditors that you're not aware of. And also it means that sometimes we have heirs that come out of the woodwork and say, hey, I should be a part of this too. And sometimes what they will do is they will attack the will. The first aspect that you have to deal with in probate is to determine the validity of the will, and so people can try to attack it. So sometimes being public is not the best thing. That's why people very often will go to a trust. And we talked about living trusts last time. A living trust, now people hear about living trusts more and more. They're both there's both the irrevocable trust and the revocable trust. And the kind of trust that we generally deal with is a revocable trust, because you can prepare the trust, you can put your assets in the trust, but you can also revoke it whenever you want to. Even when you put your assets in the trust, and we talked about different assets like your real property, your house, your land, and then other personal property, which is things in your home, piano, artwork, furnishings, or whatever. Also intangible property, we talked about music and all those things. You can still control those things, which means you can sell them, you can refinance your home, you can still have control over it, and you still own it. So you don't lose control even though it's in the trust. But people very often will make a living trust, and then they're told by their attorney that also that the attorney is going to make, he or she is going to make a will. And they think, wait a minute, I was trying to avoid a will. Why do I have a will? Well, generally the will that's prepared when you have a living trust is called a pour-over will. And it's a pour-over will.
Pour.
And one good way to imagine that is, it is the saucer that catches the property that may not have been retained in the trust. Every once in a while, you either acquire more property that was not obtained or referenced in the trust, or there may be some mistake. Sometimes a piece of property that you thought was in the will, was in the trust, does not make it in the trust for whatever reason. For instance, we talked last time about when you have a trust, you have to make sure that your deeds are revised so that they reference the trust. So if there's a property that doesn't make it into the trust, this pour-over will be there. And usually what they say is you want the will to follow the instructions that are laid out in the trust. So that is one tool, another tool that we use. Then we talked a little bit last time about the power of attorney. And the power of attorney is also a document that is used whereby in the event you become incapacitated, and sometimes even when you're not incapacitated, you designate another individual who is known as the attorney in fact, or an agent. You're the principal, they are your agent, and they do your bidding according to the instructions that you place in the power of attorney. In the power of attorney, if you designate it as a durable power of attorney, they can take that document and go to the bank and make actions on your behalf. If you include it in your power of attorney, they can handle your real estate. They can even sell real estate. You can define in the power of attorney exactly what kinds of powers they will have, the degree of the extent of the powers they may have. You may just have a power of attorney and say, I want my sister Susie to have the right and the privilege of going down and the authority of going down and handling my account at Bank of America. But I don't want to touch my account at Wells Fargo. So you can make it very limited, or you can make it very broad. And it's up to you, and that's the beauty of it.
May I ask a question, please? And audience, we are sitting in her feet because this is the expert, and so we want her to talk. We are at your feet. Now, a power of attorney, can it be as simple as filing papers in Norwalk?
Yes, that's a very good question. That's an excellent question. A power of attorney, because it can be very, you can make it very limited. Or it can be very broad. It can be as broad as having all the powers that you would have if you were an individual, if that person were you. So if it's a very broad power of attorney, and if it includes power over your real estate, that power of attorney in particular must then be filed and recorded down in Norwalk at the county recorder's office. So it's very important to know that if you want them to be able to have to deal with your property. It will give notice to everybody else that may deal with your property that not only do you have power over your property, but your agent also has power, and that's why they want it to be recorded. Now, if you want to revoke it, and you can revoke it, you must, however, also have a written revocation of the power of attorney, and it too must be recorded, and you must make sure that you give a copy of that revocation to your attorney in fact, so they know time's up. I don't want you to do anything else. Your power has ended. And it would also be a good idea if you have a bank or other place or establishment where they do business to also let them know this power has been revoked. Because otherwise they wouldn't know. And sometimes if people want to, we get into elder abuse sometimes, if they want to continue and pretend like they're you without your knowledge or authority, then you want to make sure that you stop it.
And that stays in effect until you change it, or until you
It stays into effect until you change it. That's also a very good question. That reminds me of another topic. It remains in effect until you terminate it.
Okay.
Or until you pass away.
Okay.
Because very often people will say, a person has passed away, and they'll say, oh, well, I've got power of attorney, so I can deal with that person's property after they're dead. But no, the power of attorney ends. Now, a living trust will continue through your death, because part of the purpose of the living trust is not only to give somebody, your successor trustee, power while you're alive in the event you become incapacitated, but it also gives them power to disseminate your estate at your death. So the living trust, like a will, will continue on. A will, you have an executor, and the executor is a person that will make sure, that will enforce and carry out the determinations and the instructions of the will. Likewise, with the power of with the trust, you will designate a person that's known as a successor trustee. They're almost like your alter ego in a way. In the event you become incapacitated, they will step in your shoes and they will manage your property and they will manage your assets. And if need be, sometimes they will even sell assets if it appears that they're going to need, they have the power to even sell assets if they will need those assets to keep you going. So the power that you're giving them is very, very important. It's very, very broad. The other aspect of having a power of attorney and a living trust is it is unsupervised, because it is private. There's no one looking over their shoulder. That's why sometimes I like to recommend, and people have pros and cons, but I like to sometimes recommend that you have two individuals as a successor trustee, because they can sort of, and don't get two people who know each other real well.
Partner up on you.
Partner up on you. Sometimes you think my children, they have my best interest at heart. Not always. Elder abuse generally stems from within the family. So you can't always assume that they're going to be the ones that are in your best interest. And that's very, very sad, but it's also very, very true.
Now, the documents that you have to administer for a power of attorney, can you do that yourself and get it notarized, or should we have an expert like you?
You can do it yourself, and you can have it notarized. And there are books where you can prepare your own power of attorney. There are documents in the library. The only reason why I think sometimes it's useful to have an attorney is because there may be intricacies about it that you may not be aware of. For instance, if this particular power of attorney must be recorded, you may not be aware of that. And so there may be aspects of it that you would need or could benefit from having expert assistance with. Now, there are two other documents that I'm going to raise now, because I want to talk a little bit today about not just how you pass on your estate or your assets at your death, but I want to talk a little bit about incapacity, and I want to talk a little bit about documents that will not only help deal with your financial affairs, but documents and instruments that will also help deal with your health. Because when we are incapacitated, and you may have a car accident, or you may have a stroke, or
Okay.
something may happen to you, and you may be incapacitated temporarily.
Okay.
You may have certain desires or preferences about what kind of medical
Right.
treatment you want to
Right.
receive. For instance, some people say, you know, when it's time for me to go, it's time for me to go. Don't try to extend my life. Don't give me any special medical treatment. Don't give me CPR. Don't give me a ventilator. And that may be their decision. But there are other people that may say, honey, the Lord created the doctors, and He's given us wisdom.
Exactly.
And they have the technology. I want you to pull out all the stops.
Use it.
Okay.
Use it.
Okay.
Okay.
Or you may have something in between. You may have something in particular that you want. So in that instance, you can have a living trust, where in a living trust you can designate the successor trustee that you want to handle your affairs when you're incapacitated. But you can also create, and you would be advisable to also create something called, and they almost have different names now, and people recognize them by different titles. Something called a medical advance directive.
Okay.
It's a document that sometimes hospitals have, or doctors have, or
Okay.
even documents that you can just get through an attorney, or
Okay.
even through different resources, sometimes even online. The AMA, the American Medical Association, produces a form also. Or sometimes it's known as a healthcare power of attorney.
Okay.
That is designed by statute. And there is a statutory form that you can use, or even a lawyer can draft it also specifically for you. And in that document, it's very, very crucial. You will identify, again, an agent or an individual
Okay.
that will help enforce that document, or that will be available to help answer or make decisions on your behalf when you're unable to do so.
Okay.
Now, what I always like to say to people is, before you, the reason why we talk about plan, before you actually prepare this document, you want to sit down and think about
Yes.
just exactly what
and be in your
is
right mind.
important
Right.
to me.
Yes.
Am I a person that can't tolerate a lot of pain? Am I a person who wants them to pull out all the stops for me? Am I a person that I want them to give me CPR, but I don't want to be on a respirator? Well, you know what you also need to do, and I recommend this highly, is to talk to a health care provider. When you say respirator, there are ventilator,
Okay.
there are different types.
Okay.
There are people that go on a respirator and only have to be on it for a certain period of time, and then they come off and they're okay.
Okay.
So be informed. Also, if you have a particular healthcare facility, an HMO or whatever, talk to your doctors. What do they mean when they say end-of-life care? What kinds of things can they offer? So you want to get a little bit of information in advance, and don't wait and say it's only for people that are, up in age.
certain
Right.
ages.
Exactly.
This is another thing I want to say. As African Americans, we have a higher mortality rate than some of the other races, plus, or groups. Also, we are often exposed to violence and other factors that cause us to be susceptible to injury
Okay.
and to death, unlike others.
Okay.
So that's why it's very, very important
Yes.
for us to be very cognizant of that. Now, I've talked about the power of attorney for finance. I've talked about the healthcare power of attorney, which is very specific, only deals with healthcare, and an advance directive. The other topics that are dealt with in an advance directive is whether or not you want to have organ donation. You make those decisions, and sometimes people do, and sometimes people don't. Sometimes they want to donate certain organs. Sometimes they want to donate their body or certain organs to an individual to extend their life, or for science or for schools. So you can make that determination there. You could also make a determination about burial. Do you want to be cremated? Some people do not believe in being cremated or do not want to be cremated.
Okay.
You can also identify that in that particular document. And it relieves the family. If you have already made those decisions, you don't have family members fighting with one another or having to guess what is it the mama wants, or having to say, well, I heard her say one time, let me go, and somebody else said, well, no, she said something else, or you just want to let her go because you want the house. You know, you don't have all those, you avoid those. So it really is important to go ahead and make those decisions and to get the information in advance. You may have a particular condition, and that condition may mean that at some point in your life, or as a condition progresses, you may be faced with certain decisions about care, decisions such as whether you want to be institutionalized or when. Do you want to die at home? Do you want to die in hospice? Those kinds of decisions can all be addressed in a healthcare, an advance directive. Now, very often when you go to the hospital, the doctor will say, or some people have heard of a do not resuscitate order. It's called a DNR. If my heart stops, honey, just let me go. Well, I often say to people, think and think twice. If you sign a DNR, or do not resuscitate, and I've talked to a lot of healthcare providers, and if you talk to healthcare providers, sometimes nurses and doctors behave a little differently with regard to your care. They may not be quite as aggressive. Now, I was not aware of this until I began to, I've been around a lot of, healthcare providers and seen a lot of people who have had both. And I began to inquire. And many doctors and healthcare people say, they don't always behave just the same. So you want to, that's why it's useful to be aware and to think about it. So you may not necessarily want to go to the extent of having a DNR. Also, there is, people also sometimes will say whether or not they want to have hydration or food, artificial administrative food removed. And if you have a DNR, sometimes they're going to say, well, if she's close to death, or if we think she's about to go, and we think she's going to be just in a persistent vegetative state, we know the story of, I cannot think of her name, but yes, yes, exactly. So if you want them to be willing to pull the plug and to also pull hydration and food, you can say that. But if you don't want them to do that, there was this big question, did you want it or didn't she? That information can be placed in these documents. I'm going to talk about a last document called, or last instrument called a conservatorship. We've all heard of conservatorships. A conservatorship, there are two types. The most important aspect of a conservatorship is that it is all court ordered. It means that the court will designate the person who will be the conservator. The conservatee is the individual who is being cared for, and the conservator is the person that takes care of them. And the court will determine this. Now, if you want to, you can nominate a person that you would want to be as your conservator, and you can place that in your living trust. That's another benefit of having a living trust. Also, a power of attorney or healthcare directive, a healthcare power of attorney, you can also designate a person that you want to be as your potential conservator, because we have heard in the news that there are people that are not good people, and they will see somebody that's living alone, that appears that they can't take care of themselves, they have some assets, a house, or whatever, and they just take it upon themselves to waltz this person into court and say, this person needs to have someone care for them.
Oh my goodness.
And they've been taking advantage of them. No, technically, and what we discovered was that even though it's supposedly court ordered and supposedly court supervised, the monitoring really was not in place the way it should have been. In a conservatorship, there are two types. There's a conservator of the estate.
Okay.
That's a person that would handle only the financial estate
Okay.
and of the person. That can be the same person. They can have the same authority over both, or it can be determined that only a conservator of the estate will be granted, or only a conservatorship of the person. But if it's of the person, whoever is your conservator, they can make a determination of where you live. They can move you out of your house. They can put you in an institution. They have all power, almost, over you. And so it's very, very serious when we use these types of instruments.
We're down to the last couple of minutes of the show. One of the things I want to ask, from state to state, the laws differ?
Laws do differ, that's
Okay.
right. So whatever your state is, you have to be cognizant of, and that's why, for instance, if you have property in another state or whatever, you want to find out what that state's rules are.
Okay. And secondly, cost of living trust. Give me a range, please.
They can range, they can vary. Some people will have them be maybe $500 or $600 or $700 if you're just doing a simple document and you're just doing one document. In California, generally now, attorneys will do all of those documents for you.
Okay.
So you're getting up maybe $1,000, a couple thousand, maybe a few $1,000
Okay.
sometimes. It depends.
And a living trust covers one person. It doesn't. It's not a family kind of deal, is it? Or
There can be a living trust, especially between husband and wife.
Okay.
There can, and that's the reason why it's very important to do it in advance, is because sometimes you can get special tax benefits
Okay.
by having the husband and wife and do a living trust together. Let me say just one last thing.
Okay.
African Americans are the individuals who are the least coupled. So very often we don't have a traditional husband and wife.
Right.
Also, the reason why you want to investigate it is because sometimes you have people that you think are married or have separated, but they have not formalized the
Okay.
divorce.
Okay.
And so very often you find out Aunt Sue and Uncle Joe, we thought they were long gone,
right.
but they were still married. And then you've got to go back and find
another
that spouse, and so that's why planning
Yes.
is so important. So you
Yes.
have fewer surprises.
Yes. Well, you know what? You have given us so much information. We appreciate that so much. To you, our viewing audience, don't forget to plan. I know we don't naturally want to plan, but we have to plan because we have to live this life. So, writers, we'll be happy to refer you on to Attorney Grissom. Take care of yourself. Until next time, know that we love you and God bless you in Jesus' name. Thank you.